start, can I just check everyone can hear me? If you just give me a wave. Yeah, that's great. Thank you very much. So during the initial introductions, it'd be ideal if participants keep the mics on mute. We find that helps with our connectivity, but because there's only a limited number today, I don't think we'll have any problems, so we should be okay. If we do have some connectivity issues, I might ask people to just turn the camera off as well, but I think we're okay. It seems quite stable. My name's Stuart West. I'm a reporter with the DPEA, and I've been appointed to consider this Section 36 application under the Electricity Act for the proposed wind farm at Hollandmey. Hang on, we have somebody else joining us. Adam Patterson. Okay. Right then. So I can confirm that I'm going to take a full note of the meeting. So if there are any issues with connectivity, don't worry. You should be able to follow along the discussion from the notes. And if necessary, we can follow up through correspondence after the meeting, anything that's missed. This meeting concerns the arrangements for any inquiry or associated procedures necessary to consider the case. It doesn't form part of the inquiry itself, so we're not going to be considering any of the merits of the case, as I'm sure you understand. The agenda was circulated last week, so parties will have had opportunity to consider my current thinking on the matter. So hopefully we'll be able to progress through quite quickly through the various points, only pausing where there's any disagreement. Firstly, we'll go through a little housekeeping. So the meeting's being recorded and broadcast live. Douglas, who you've met from our IT team, is going to be on hand in case there are any issues, technical issues. In due course, the meeting will be uploaded to the website. So in accepting the invitation, you've agreed to being recorded. I will offer an opportunity for anybody not comfortable with being recorded to either leave or to turn off the camera. You may find it useful to use the grid, but I don't think that that's necessary. I think everybody can see everybody at the same time in this meeting because we've only got the 4 participants. So I'll keep an eye on participants. If you want to speak, just put your hand up and we'll bring you into the conversation. Finally, even though it's a virtual meeting, it'd be great if people could just keep the phones on silent or switch them off so that we can get through without any disturbances. I've not planned any formal breaks, but if the meeting's still underway, say an hour, we'll have a quick discussion to see if people think that'd be useful. So we'll move on to the introduction of parties. So I'll now invite you to introduce yourselves. We'll start with the applicant.
Thank you, sir. My name is Emma Payton. I'm a director at the firm of Shepherd and Wedderburn, and I'm representing the applicant Scottish Power Renewables UK Limited. I'm accompanied by a number of people from the applicant in the room today, but for the purposes of your notes, I'll just say that I'm instructed by Fiona Coyle, who is the divisional solicitor for the applicant. Thank you.
Thank you. And from the council.
Yes, good morning. So my name's James Finley, King's Counsel. I'm instructed by Rhoda Banfro, and we are the only 2 appearing for Highland Council today.
That's great, thank you very much. Does anybody have any preliminary questions or issues to raise before we get underway? No, that's great. Excuse me, I'm doing this the old-fashioned way with pencil and paper, so if I pause and I'm looking down, don't worry, I'm working through it. So we're going on to item 3, which is the code of practice. So as I'm sure you're aware, there's no detailed procedural rules for the conduct of inquiries under the Electricity Act. However, the DPEA has produced a code of practice modelled on the 2013 Planning Appeals Regulations, and I intend to apply that code in this case. If you've not seen it, the document is available on the DPEA website, but I'll also include a link in my note of the meeting. Essentially, it allows for flexible procedures, so each issue can be dealt with by the most appropriate mode of examination. This could be an inquiry session, a hearing, or further written submissions. With many of the issues in this case, you'll have seen from the agenda that I'm satisfied that sufficient information has already been submitted for my consideration, so I envisage no further procedures required for those. When I write my report to Scottish ministers, I'll take into account all of the environmental information submitted by the applicant, together with the consultation responses and letters of representation that have been lodged. I just want to highlight, mainly for the parties following along or who are watching this back at home, that if you're not familiar with procedures for an inquiry, the type of procedure that we're following, or the absence of any further procedure, doesn't necessarily indicate how important something is, if it's a particular issue. And I will be giving full consideration to everything that's been submitted. And also, for the benefit of people, for third parties in particular, I just want to take a quick opportunity to outline the differences between an inquiry session and a hearing session, because there'll probably be a little, or there will be a little discussion on this later on. So hearing sessions take the form of a structured discussion between the parties involved, which I'd lead. There's no formal leading of evidence or cross-examination. I'd prepare an agenda which would be circulated in advance. Everyone who's going to take part in the hearing can participate in that session. There's no need for legal representation, although parties' lawyers can take part in the discussion. Hearings are generally more informal than inquiry sessions and are particularly suited for topics where there's a difference of opinion on less technical issues. Whereas inquiry sessions, each party is invited to present evidence in turn, and this is subject to cross-examination by those with an opposing view. Parties in inquiry sessions are usually legally represented, although that's not essential. I'd also have questions in an inquiry session. They're more formal than hearing sessions and are particularly suited to topics where there's a lot of technical evidence and differing views from experts. So you'll see from the agenda and its annexes, I've already set out how I think the cases should proceed. However, I note there has been a suggestion that's been made that the landscape and visual session could be held as a hearing as opposed to an inquiry, and we'll discuss this a little more as we go through the agenda. Site visits are another important part of my evidence gathering to ensure that I fully appreciate the issues relevant to the case and the proposed development. I've not yet undertaken any unaccompanied inspections, but I intend to arrange these as soon as I'm comfortable we have the most up-to-date information regarding the proposed development and any other proposals in the vicinity. Does anybody have any general queries on the code of practice before we move on to item 4? No? Okay, that's great. So item 4 is the additional information. Firstly, you'll have noticed, if we look at the LVIA first, you'll have noticed the email exchange yesterday that sets out the initial positions of myself and the applicant regarding an updated cumulative landscape visual impact assessment. Before I come to a final decision on this, I would be interested to hear from the council their views as to whether the developments that are in the planning system at the moment they believe are relevant in terms of their own objection on cumulative impacts or sequential impacts.
So I would like my professional witnesses today and or yesterday to have an input into that. So I'm not in a position to give you a definitive response, although I understand from discussions with the applicant that they are planning to put in a cumulative LVIA in any event, and we've had some offline discussions about the dates for that, which no doubt Peyton will allude to in due course. So I don't think it's a contentious issue that I understand that just for stealing is paying that further document to place, or certainly to explain the LVIA chapter of the EIAR, which would need to be an EIA document. And we have no objection to that either. And we've had some discussion. There are maybe some issues about timetable, but so that's as helpful as the responses I can give you. But I'm afraid I'm not able to give you a direct answer to your question.
No problem. Can I just turn to the applicant there then and ask if there's anything you'd like to add or to give us an updated position?
Yes, thank you. The applicant noted the request to provide an updated cumulative LVIA, and we are content to provide that if it's considered necessary and relevant from the council's perspective. We'd set out in our email exchange, I think earlier in the week, about the additional proposals now at application stage, and we propose that if it is considered that an updated cumulative LVIA is required, then it addresses those sites subject to any additional applications the council would wish to flag to us. In addition to that, we've also, as Mr. Finlay alluded to, made the council aware that our landscape witness was not involved in the preparation of the original LVIA. And so as a result of that, we would want to provide information and materials demonstrating how our landscape witness would have approached the LVIA if she had been the original author. And so we anticipate providing further LVIA information in that regard, alongside any updated cumulative information. So on that additional information for LVIA and the timescales proposed there, we did note the provisional timescale of 4 weeks out in the meeting agenda. We do have some logistical difficulties at the applicant's end, giving the existing commitments of the applicant's landscape witness, meaning that the witness is probably likely to require quite a bit more time than the 4 weeks that's been proposed. We've discussed the matter with the council's legal team, who've confirmed that provided the applicant has produced a comprehensive LVIA document by a date of the 25th of August at the latest, and the council then would have 3 weeks to review that and submit its report, then those timescales would potentially be manageable from their perspective. And again, from both parties' perspectives, the inquiry could proceed as planned in October for the dates that were set down, if that was also acceptable to you, sir. It's the applicant's view that it's in all parties' interest that all the LVIA material, i.e. the cumulative material and any additional material arising from different authorship is all incorporated into one comprehensive document that we put in at an earlier stage as opposed to at report stage, for example. And again, we didn't intend to lodge that if it was agreeable by the latest date of the 25th of August. And of course, if it's available earlier, then we would of course seek to do that. And that date, as I understand it, is been provisionally agreed with the council's legal team, and as I say, would allow the inquiry to still proceed in October, subject to your views.
Sorry, somebody.
Well, it may have just been me. Perhaps I understand the issues created by availability of the applicant's expert, and the Highland Council have taken steps to try and accommodate that insofar as possible, and to keep the inquiry date we have, which would seem to be a sensible option. Just one minor, I think I'd suggested 4 weeks from the 25th of August for us to reply, but I think that should be, which might make a slightly shorter turnaround for recognition, but recognitions will be short anyway. But given we're going to have to deal with a potentially new methodology, I still think that's highly doable. Our witnesses are familiar with the area and familiar with the proposal, but just as an abundance of caution, 4 weeks. Now that may tell us the timetable from what one might have been expected, but I think in trying to accommodate both keeping the inquiry date and the applicant's experts' availability. That would hopefully provide everyone with sufficient time to prepare.
Just looking through my timetable here that I've got, which we'll come on to shortly. It will obviously bring things quite close in terms of preparing any hearing or inquiry statements relative to the topic. 4 weeks from the 25th would be the date that I'd be expecting those to come to myself. But we can talk on that shortly and see what we think is realistic in terms of narrowing it. I think for a full for the document that you're describing, I'd be willing to take that for the 25th of August with the council's agreement. What I could potentially ask is whether or not it would be possible for just an interim submission of even just some wireframes, just to aid my own site visits, so that it'll give me just an indicator of how relevant those are when I go to those viewpoints. But of course, those would just be for my reference, and then the interpretation of those would come through when the LVIA's drop submitted.
I do think that should be something that we should be able to accommodate without any difficulty.
Okay, that's great. Thank you very much. So we'll come on to the timetable. Oh, sorry, Mr. Finley.
For your site visit, my recollection was that there might be some additional viewpoints that the applicant's expert wished to refer to. And again, going to be made in advance so that if you're carrying out site visits and there are additional viewpoints, you have the wire lines, graphic material for those.
Yeah, that. Sorry, Mr. Finley.
Your site visit time.
I'm afraid you're breaking up slightly. So, what it might be worth doing with yourself is just turning off your camera. It sometimes helps. But what I've got from that, correct me if I'm wrong, is that there's the potential for some additional viewpoints to be included within the updated cumulative LVIA, which I should be taking into consideration when I make my site visits. And if the wireframes can be submitted to myself earlier than the 25th of August date to aid my site inspections, they would include the additional suggested viewpoints.
Yes, apologies for breaking up. Absolutely.
No problem.
I think they're the applicant's viewpoints.
Okay. That's great, thank you.
And I would say to the applicant that it would be helpful if there was liaison with the Highland Council in advance to choose the exact location of the viewpoint.
That would be ideal, thank you.
We'd be happy to do that.
That's great. So when we come onto the timetable in shortly, we can have a look at a realistic date for that. The only other thing that I've got here in this section to discuss at the moment is that an update would also be required for changes to council or government policy since the submission of the application. Now, I note that the applicant's already submitted comments on MPF4, so that update, either as submitted or in a revised form, could be given as part of the submissions for the proposed session on the legislative and policy context, if that's acceptable to folk. I think that's the only other thing, unless people can correct me. We'll see if there's any additional further information that we require.
From the applicant's perspective, in terms of policy, obviously there have been some changes since the application went in, and there's the NPF4 document is already with you. We would be happy to provide an interim update if that was helpful to you, but equally we're conscious that hearing statements will be submitted and those will be full, and so that would cover the relevant policy and legislation in place at the time.
Yeah, no, I'm more than comfortable for it to be submitted at that point. Is there any other additional information that parties believe needs to be reviewed? I'll start with the applicant.
There's nothing from our perspective. Thank you.
And the council? That's great, thanks. So item 5, my provisional assessment of the main issues. So in my understanding, the items listed in Appendix 1, if people have the agenda to hand, haven't changed since the agenda was issued. So for a number of issues there raised by third parties, I don't consider that any further information is required. I will consider in detail the information that's already been submitted on those topics in the preparation of my report. But looking over the table at Appendix 1, starting with the applicant, can you advise if you agree with my findings on those specific issues that don't require further procedure?
Yes, we agree with those. Thank you.
And the council?
Yes, but used on this with them already. There are 2 issues that may arise under the conditions section, one relating to transport, which deals with roads repairs, and secondly relating to biodiversity gain under ecology. So whilst we're not requesting a hearing or further procedure on those points, because as I understand it, they don't go to the principle of the proposal. They may be matters that arise under the condition session should they not be capable of agreement in advance, and we've got quite a lot of time between now and the inquiry to at least see if we can agree or narrow the issues between us. Otherwise, in agreement.
Yeah, great, thank you. So in terms of written submissions, aside from further information I've already mentioned there in terms of the LVIA regarding the cumulative landscape visual impact assessment, I don't propose to seek further written submissions on any topic at this time. However, I am open to discussion today as to whether the proposed hearing sessions are absolutely required, or if parties believe that those could be addressed through further written submissions as an alternative. But we'll move on to those just now, those 2 hearing sessions first before we come to the LVIA session. So the draft conditions one on the final page of the agenda, issue 3 requires the applicant liaise with the council and other relevant parties to prepare that set of draft conditions. We can discuss the time frame for submitting that under item 8. However, it would be useful to know at this time, I suppose, if there's any progress so far on the conditions, or if there are any views as to when the first draft of conditions might be available. The applicant.
Yes, so we're in a stage where we've almost got a finalised set of draft conditions, which we would intend to share with the council in early course.
What are the parties' views on the suggested approach of preparing these in advance and then considering them in a dedicated hearing if agreement can't be reached? It seems to be the standard approach to dealing with this, and are parties comfortable that that's the best way to do it?
Yes, and I think it's the most efficient way as well, because certainly Highland Council's experience is that they can agree motions, but those that aren't agreed, then it's I think it's the most efficient way of dealing with it to have a full session on conditions.
Yeah.
Okay, thank you.
The applicant would agree with that as well, and of course we'll work with the council on the conditions throughout the duration of the inquiry, and it might be that we can reach agreement on a number of matters, and a hearing may or may not be required, but I do think it's sensible to programme one in case there are outstanding issues or you've got any questions in relation to the conditions.
Thank you. So we'll agree on that, and then when we come to the timetabling, we'll take a formal note of that. So in terms of the other hearing, which is the planning and energy policy context, I've also suggested a hearing on that. Are parties happy with that approach as well? I'm sorry, the applicant.
From the applicant's perspective, we are happy with that. The policy in the area is quite fast moving, so we do think that it would benefit from a hearing to ensure all matters are captured and equally that also gives yourself an opportunity to ask any questions that you may have.
Okay.
Yeah, yes, and it's one of those cases where there have been a few inquiries with submissions on MPF4 and the interrelationship with the Highland-wide local development plan, and one doesn't know when those decisions are going to come out, although there has been a decision on a wind farm called Mill Buoy 2 days ago, which touches as a reporter's decision rather than a Section 36 decision, which deals with it. So I think it would be useful to have a hearing session so that it can capture such matters, and there may be a difference of approach. So it may well be oral submissions would be useful in this instance. It's not a settled area of that relationship is not yet settled. So I think a hearing session would be useful.
Okay, I agree with that. So in terms of landscape and visual impacts, I'd initially suggested that this should be dealt with through an inquiry process. However, I do appreciate that there is pretty limited disagreement between parties regarding landscape and visual effects. So starting with the applicant again, I would be interested to hear your thoughts on the need or otherwise for an inquiry and any benefits you perceive of one approach or the other over the other.
From the applicant's perspective, as set in its position statement, we had proposed either a hearing or an inquiry session for this topic. We're content to go with an inquiry session if that is your preference, but we've indicated that either, from our perspective, would be fine. Obviously, for a hearing, it's possibly more suited where the issues are slightly narrower. But we're really in your hands on that one, sir.
And the council, is there any preference?
Well, the Highland Council's general position is it prefers hearing sessions to inquiry, and they can be more effective. And just by way of an example, there was a hearing session on Hollandmey wind farm, which is, I think it's Hollandmey, which is just around the coast from Hollandmey.
Sorry, Mr. Findlay, we've lost you again there.
I think our preference would our preference would be for a hearing session.
Okay. So what we'll do, I'll take this and consider it and read through a little more and finalize things in my notes. But when we come to talk through the timetables at the moment, we'll talk through both potential options. And I note that there's a preference there from the council for a hearing, and the applicant is happy with either way. And I do feel that it is narrow enough that we could deal with this through a hearing. But rather than just make an absolute decision at this point, I think that it'd be most appropriate for me to go and just make sure that I fully understand all of the matters in dispute, and then I'll confirm that when at the latest when we release the meeting note, which will be next week. So before we move on, can I just ask if there are any other significant issues raised that we haven't discussed so far or that I've not put in my agenda in the appendix?
I wasn't sure if you wanted to consider the reporter's initial views of scope of further procedure, which is the final page of the agenda. The applicant just had one very brief point to make on that list, and it relates to the planning and energy policy context list.
Yes.
And it's bullet point 2 there, which is national policy and guidance on energy, which is listed. So we just wanted to suggest that that particular topic is extended to include legislation as well as policy, which I know is also the name of the topic in the appendix 1 in the table as well. So I think you were probably contemplating that anyway, but just to suggest that that's expanded to legislation, so that it can cover matters such as climate change legislation. There's also reference to national in there, and the applicant was just wanting to check that international documents could could also be considered, for example, international treaties. So it was just those 2 points really on that bullet, and just to refer to legislation and also international documentation.
Yeah, I think that it's my my own bullet point that's maybe at fault there. So no, I think in terms of planning and energy policy context, I was envisaging all relevant legislation and policies and guidance. So I'm more than happy for that.
Thank you very much.
Okay, so participation, and this should be quite swift because of the limited number of parties for item 6. So I mean, we only have the 3 sessions, and both sets of people are wanting to participate in each, so we can move this quite quickly, and I can just get confirmation from parties that they would like to take part in the sessions on landscape and visual, on policy and energy context, and on planning conditions.
Yes.
That's great, thank you very much. And we'll move on to the in terms of, well, one thing that is worth speaking about at this point, if we were to go with an inquiry session for the landscape and visual impact, can I just ask how long parties believe we should set aside for this based upon number of witnesses and the scope of the disagreement? I'll start with the applicant on this, just to see how long you'd anticipate such a session to last.
Certainly. So if it was an inquiry session, we would think that we would be able to do our evidence within a day. The council, of course, required to present their evidence as well. So it was our suggestion that 2 days might be sufficient, but I'm happy to hear Mr. Finley's views as well.
And how many witnesses would you propose to present?
We will only have one witness, which is Mary Fisher of Absaline.
And the council?
I can confirm that I think 2 days would be appropriate. We have 2 witnesses, one landscape. Well, I'm envisaging we'll have 2, one landscape, one visual impact. The unknown is the extent to which the new material may take further time, but I don't anticipate it's going to take significant time. So I would think 2 days in total, given the level of agreement, would be should be adequate if it was an inquiry session. I think if I can jump ahead, if it was a hearing session, obviously will be more in your hands, but I would have thought a hearing session might finish within a day.
Okay. Yeah.
Should finish within a day.
Would you agree with that?
I think the applicant probably would agree with that, yeah, from our perspective. Thank you.
That's great. So in terms of the other sessions, my initial thoughts were that we'd be able to do both of those in a half day each, to combine them both into a 1 day, 1 day for both. Would parties agree with that?
From the applicant's perspective, we had thought that both could comfortably be dealt with within 2 days. They may take less than that, and it may well be that we end up with a half day each. But our initial thinking was comfortably within 2 days.
So that's good. Okay, so if we err on the side of caution, then say 2 and hope for 1.
I think that's unduly pessimistic. 2 days for the hearing sessions. Leaving aside well, if landscape and visual was in.
Sorry, Mr. Finley, we've lost you again.
2 days, but for the policy, it's so bad. Anyway, for the policy and condition session, that should.
I'm afraid we've lost your audio, but what I'm hearing if you want to turn your video on and give me a thumb up or down, is that you'd envisage that it'd be 1 day.
For the policy and conditions session.
Yeah. Okay, so if we look at dates, location, likely duration in total, we've kind of touched on those through that last item, but it leads us to a quick discussion on the earliest possible dates for the inquiry and hearings. I've suggested that the sessions take place the week commencing 16th of October, and parties have informally agreed to this. Can I just seek confirmation for the meeting note that representatives of the applicant and council are able to attend sessions during the week of the 16th?
The applicant's representatives are available and able to attend the week of the 16th. Thank you.
And the council?
Yes.
Great, thank you. So do your witnesses have full availability for that week, or would specific dates need to be set aside for given topic areas? The applicant?
Both of the applicant's witnesses have full availability for that week, so we don't have a specific preference on dates. Thank you.
Okay. And Mr. Finlay?
As I understand it, full availability, although given the timetable, it may be preferable to start on the Tuesday, allowing people to get up to that part of the world on Monday.
Okay. So, yeah. I'm looking at my calendar here, my timetable. So I'm looking at if we were to be working. Unfortunately, on the Friday can be quite a challenge. I could maybe do half of the day on the Friday, but what I'm looking at is if it was going to take 4 days. Yeah. So yeah, we could start on the Tuesday, and if we were to put the landscape and visual sessions down for Tuesday, Wednesday, and then Thursday, and potentially going into Friday morning for the other sessions, would that work for parties in terms of logistics for travel?
That would work from the applicant's perspective. Thank you.
Yes.
Okay. So we've now agreed that there will be a landscape and visual session, be it inquiry or hearing. I'm erring on the side of caution and planning for an inquiry at this stage, which would say would be on Tuesday, Wednesday, which would be the 17th and 18th of October. And then a planning conditions and planning and legislative context hearing on 19th, potentially spilling into the 20th. I suppose that would again depend upon how much agreement we have on the planning conditions in advance, in particular. So if we put the planning conditions first, I'm just conscious that we'd have to advertise these and then stick to the timetable. So if we put those down for the 19th, and then we put the planning and legislative context down for the 19th as well, that should cover us, I believe, and potentially into 20th. Can parties confirm that they're available on those dates again, just for my notes?
Yeah, I confirm from the applicant's perspective that the parties are available. Thank you.
That's great.
Yes, as I understand it, council witnesses would be.
And before we just wrap up this this item, given the scope of the parties that have opted into the process, being just the applicant there and the council, I did want to just seek views on parties regarding undertaking the sessions in person versus holding them remotely. Obviously, we've witnessed here this morning that there can be some issues with connectivity, which can be a challenge when we go virtual. But is there any preference for physical versus virtual meeting if we start with the applicant?
From the applicant's perspective, we had anticipated in person, and we're more than happy to attend in person if that's your preference, sir. We're also mindful that virtual inquiries have worked very well in the past, and we have participated in a number of those, and they've been carried out successfully, and that can also improve accessibility for others as well. But we had anticipated in person, but we're in your hands if you've got a particular preference on that.
Okay, and does the council have a particular preference?
My understanding that in general terms, the Highland Council is broadly neutral, if not preferring virtual sessions, but for my own part, if it is to be an inquiry session, my view is that an in-person works better. If it's to be a hearing session, then that's less important.
So
I
we
think
have
agree with that.
Okay, yeah, that makes sense. So we have reviewed potential venues. Obviously the council is going to be more familiar, but we had potentially suggested the Pentland Hotel, which is in Thurso, as a potential venue. Would there be any, well, you don't have to answer this now, but if the council is aware of any other potential venues in the locality that's accessible to the public with good internet connection, which is one of our critical things for our streaming service, if you could just let us know informally and copy in the applicant, and then we can make some inquiries locally as to the appropriate venue. So
I say, as well as the Pentland Hotel in Thurso, there is a hotel, the Mackay's Hotel in Wick.
Okay.
My experience actually is potentially a slightly better venue, but
okay.
It's
no, that's good to know. We can inquire now that we have our dates. Can inquire for availability, and it's good to have some options. But if there are any others, including council buildings, please do just let us know in the next week, and we'll try to make arrangements.
Certainly, if I can add to that, I know that there have been inquiries in both of those hotels, and I know that in terms of other locations, they've been difficult to get hold of in that part of the world. But there was an inquiry in Wick in Thurso in a community building that was, I think, a museum or gallery of some sort. But apart from that, I think those are the two main ones.
So, notwithstanding what we agree in terms of the sessions, following my unaccompanied site visits, which we'll discuss shortly, I might decide that an accompanied inspection is necessary as well. At this time, from my initial reading, and the fact that the matters in dispute relate to landscape and visual impacts, I'm not convinced at this time that an accompanied inspection is necessary. But after my unaccompanied ones, that may change. So the note of this meeting will set out the detailed timetable that we've just discussed in terms of the actual sessions. But we can have a look now, if we move to item 8, at the timetable for documents, written submissions, statements, and precognitions. Firstly, digital versus hard copies. The practice of displaying publicly accessible hard copy documents has now been reinstated following the changes to the legislation through the procedures through the COVID pandemic. So whilst parties will likely utilise the online repositories to review the documents throughout the appeal process, it's important that hard copies are also available for members of the public to view in an accessible place. So again, you don't have to answer this now, for the council, but if the council has any suggestions regarding the most appropriate locations for these to be held, you could let us know, so that can be actioned. That would be ideal. Thank you. So the timetable, given the dates that we've agreed for the oral sessions, we can work back to fix the dates for the submission of key documents, written statements, and statements and precognitions. A full overview of this timetable will be circulated with the note of the meeting, and there'll be opportunity following that just to give us a little bit of feedback, and we can, they won't be fixed, we can then make some amendments if necessary. So the note of the meeting will be circulated. I aim to have that with you by the 23rd of June, which is a week today. And then if we can have comments or feedback within 7 days on that, in particular with regard to the proposed timetable, that would be excellent. So I'm going to quickly go through this. Well, not too quickly, because I'm sure you'll be taking a couple of notes. But what I'd suggest for the initial set of conditions would be for the 14th of July, which is 4 weeks from now, 3 weeks after the note of the meeting. I'll slowly go through these now, and then we can come back to any that you'd like to give me some comments or feedback on. Then I've got down for the updated cumulative LVIA. I'd put the 21st, but we've already had discussions on that, so I'll change my notes there to say that the full updated LVIA will be for the 25th of August. However, if it's possible for us to get some kind of wireframes, at least, for either I'd prefer the 21st of July, but the 28th of July would work for myself as well. That would be ideal. We would then, because we're requesting these, the updated LVIA, we'd then be required to consult again. So the DPEA would do that, and that's just in our own timetable there, really. So any parties that we're required to consult, we would do. And of course, the council there, you're suggesting that we allow 28 days for the council, which I think can work for our timetable. Now I have multiple screens now, so I have down in my initial timetable that 8 weeks before the inquiry would be the submission of inquiry statements. Now if I look back, that takes us actually back to when we may need to shorten that slightly if we're allowing to the 25th of August. It's not going to work that way, is it? So what I may come to yourselves here with your experience, and you're envisaging a 25th of August for the submission of the updated LVIA, and then a period of 4 weeks, which would take us to the 22nd of September. Do you believe that that would be sufficient time to then put together your inquiry statements? I'll start with the applicant and then move to the council.
So in terms of what we were anticipating, if the updated LVIA document was submitted on the 25th of August, are you anticipating inquiry reports, and then precognitions? I'm just aware that in the past there's also been initial inquiry statements, but my understanding is that it seems to be that reports and then precognitions are now the the practice. The council
Yeah.
will also need to come in on that, but if it's the 25th of August for the LVIA document, I understood that 3 weeks might be possible for the council, but if it's 4, then that would take us to the 22nd of September. If 3 weeks was possible, it would be the 15th of September, and then recognition potentially 2 weeks later on the 29th. But Mr. Finlay may want to come in on that.
Yeah, in terms of, I'm sorry, Mr. Finlay, I've just a quick clarification. I've got the recognitions in my timetable. I've been a little bit more generous and given you until the 6th of October, but Mr. Finlay, I'm more than happy to hear your views on this.
No, that would work perfectly. As I understand it, if the material came in from the applicants by the 25th of August, we had till the 22nd of September to put our report in, and indeed, if they wish to put a further report in, they could do it by that date as well. But hopefully, we'll have the substance of their material on the 25th of August, and then recognitions by the 6th of October. That would work perfectly for us if it's to be an inquiry. And if we could have the same date, the 22nd of September, for the hearing statements,
yes,
that would work as well if it was to be a hearing session rather than an inquiry session. But all hearing statements on the 22nd would be useful. It's better to have one date, one deadline if possible.
Yeah. I do have the 22nd as my hearing statements date. Yes. So yeah, if we looked at an inquiry report and hearing statements for the 22nd of September, and then precognitions on the 6th of October, I think that covers us. If the submission of documents as well will need to be at the same time as the statements. I believe all remaining documents should be submitted at that point. The only other thing I've got here is a statement of agreement, which would be, now I've put that in as 1st of September. However, that may need to be pushed back slightly based upon the council not having sight of the updated LVIA until a week before that. So we could go for a statement of agreement on the, I don't want to push everything into the same day for you so that you've got so much going on all at once. So maybe the 8th of September, would this work for people?
Well, so can I say that I don't think it would be a problem having the statement of agreement on the 22nd of September, but primarily because it's going to take us some time to react to the new material. If the statement of agreement starts circulating in the months beforehand, hopefully the policy section of it which quite often is the most useful section, and any other bits can be pretty well finalised some time before, and then any agreement as to the landscape and visual parts can be fed into that. But I don't think there's a problem having that for the 22nd of September as a final target date.
Okay, that'd be great. If we could have an interim one, that'd certainly help with my drafting of the other elements of the report. So, yeah, we can put that on the 22nd as well. So in terms of anything else, I don't think that there's a massive amount of other things. In terms of my agendas for the hearing sessions, I'll look to submit those on the 2nd of October, which would be 2 weeks before the sessions, so that people have plenty of time to prepare there. And then afterwards, we'll talk quickly about closing submissions. So I'd envisage closing submissions from the council 2 weeks after the final hearing, and then from the applicants 2 weeks after that, so 4 weeks after the final hearing. So taking this into account before we look more closely at the closing submissions section, a party is content with the general timings there of the submissions, and that we think it's achievable. Yeah.
Yes, we are from our perspective. Thank you.
Thank you very much.
Okay. So I would expect the closing submissions to be submitted in writing rather than as part of the inquiry hearing sessions, which is becoming more and more common now. And they should also include a summary of the entire case, which again is becoming more common now. This would be appended to my report in place of my summarising the position of parties. I'm not too sure if you've had a PEM recently or if you've been going through the process yet, but this updated approach is being implemented by all reporters now, and it's intended to streamline the report writing process, which should result in my recommendation being passed to ECU more promptly than would have been the case in the previous report writing style, where it had been myself that was summarising through the report the case of parties. I can forward more information on this in due course if it would be useful for people. But it's just to make aware that when you come in to put in your closing submissions, an overall case summary at that time would be what I'd be looking for. So are there any issues with this general approach to closing submissions, or are people comfortable with that?
The applicant's content with that. Thank you.
The council?
Yes.
Thank you. So moving on to site inspections, as I said earlier, I intend to carry out unaccompanied site inspections as soon as possible after the submission of the updated information. Are there any issues with access or access to particular viewpoints that I should be made aware of, that parties know of?
From the applicant's perspective, just a couple of things to flag. The first is that if you required access to the site itself, the applicant would intend to let the landowner know about that in advance. So if you intended to do that, then we'd probably let the landowner know. And the only other matter was if you intended to go to the Castle of May. As I understand it, there's a paid entry into the Castle of May, so it's just to flag that to you.
So yeah, as part of my evidence gathering for people following along at home, I'll be viewing the site from the viewpoints set out within the LVIA and within the surrounding landscape as well, where there's public access. And as I said earlier, if after my initial site inspections, I believe that an accompanied inspection is required, we'll make arrangements for that. Most likely at the time of the hearing, to reduce the amount of travel for people, hearing or the inquiry sessions, if time allows. So moving from there, we have miscellaneous. The DPEA contact, as you'll no doubt already be aware, is Christine Brown. She's our case officer and will be your main point of contact for the case during the process. She'll liaise with myself as necessary and will ensure that documents are circulated or made available on the website as required. It would be of great assistance if the applicant could maintain a list of core documents for us, and then submit the updated list to us when new documents are submitted, so that we're all working to the same references, and Christine can keep that live on the website. Are there any questions about the circulation of documents, or are we happy to just continue as is standard?
No questions from our side. Thank you.
No questions from us.
Okay. So as stated when discussing the timetable, I aim to issue a note of this meeting on the 23rd of June. I have made notes on the updated timetable, however, and I will look back over the video. However, if there's anything that's been missed there, there will be that opportunity after receiving it for us to just firm up those dates, and I'll then issue a finalised version of the note of the meeting, which will be uploaded onto the website and will become part of our documents. So in terms of any other relevant matters, does anybody wish to raise any other matters at this stage that we haven't covered?
Nothing further from the applicant, thank you.
No, and the council?
No, nothing from the council.
Okay, that's great. So I will proceed to finalise a note of the meeting then in the next few days, and I'll aim to issue it by next Friday. All of the official dates and the proceedings will flow from the date of that note. So thank you all very much for your participation, and do look forward to moving on to meetings in person later in the year, or failing that, seeing you again in the autumn. So thank you very much, and I'll draw this meeting to a close. Thank you.
Thank you very much.
Thank you.